This is the brief on how tribal sovereignty is upending the government's arguments on birthright citizenship. So picture this, it's April 1st, 2026, at the Supreme Court for Trump v. Barbara. The government's top lawyer, Solicitor General D. John Sauer, is arguing the 14th Amendment doesn't guarantee citizenship for kids of undocumented immigrants, and he's using the historical exclusion of Native Americans to try and justify his restrictive view of who exactly owes allegiance to the U.S. First, Justice Sotomayor has shut this down instantly. The government tried to equate temporary foreign visitors with historical native tribes. Well, Sotomayor pointed out that tribal nations actually occupy a completely distinct, permanent constitutional status. I mean, it's like treating a sovereign co-owner of a land like a temporary weekend hotel guest. It's a fundamentally flawed comparison. Second, flowing right from that unique status, Justice Gorsuch exposed a massive logic trap. Sauer claimed citizenship requires lawful domicile, or residence. But when Gorsuch asked if Native Americans born today are citizens under that modern test, Sauer awkwardly agreed. So wait, how can you rely on the historical exclusion of tribes to deny citizenship to immigrants while simultaneously using a modern test that protects tribal citizenship today? Finally, building on Gorsuch's trap, Justice Barrett highlighted a huge originalist problem. She noted that the U.S. tribal relationship has drastically changed since the 1800s, meaning being subject to the jurisdiction of the U.S. just can't be frozen in time. If the actual facts on the ground regarding sovereignty change, isn't it impossible to apply a static 19th century definition of citizenship to a 21st century reality? Ultimately, the government's attempt to use native history to restrict immigration has instead proven that constitutional citizenship, federal power, and tribal sovereignty are anything but static.